Straight on to the top story that we are tracking at this hour. Now, a right to information application has revealed that the centre, in fact, sought details about digital news media publishers under the new IT rules 2021. This even after the Bombay High Court, in fact, had stayed some of its provisions. Now, around 2,100 digital news media publishers have already furnished information to the centre, and the RTI application was, in fact, filed by the Internet Freedom Foundation earlier this month. And a senior government official, however, has now pointed out that the Bombay High Court had, in fact, stayed only a section of the new IT rules and not all the provisions. My colleague Ketan now joins me live from the Mumbai newsroom. Ketan, just take us through the new IT rules that the centre is in fact talking about, and what does this PIL actually say?
Well, this PIL was filed along with other PILs last year seeking information, and this happened in August 21 when there was a stay by Bombay High Court over seeking information from media companies, and then there was a right to information that Internet Freedom Foundation filed in the first week of January, and a few days back information that government has given to them says that they have reached out to 2,100 news publishers, OTT platforms, and other publishers, and information was sought from these publishers. And these publishers furnished the information in September. So now, what needs to be seen is what the government sources are telling a Times of India report. They are saying that only a part of the IT rules have been stayed by the court, whereas activists and internet freedom advocates are saying that once the High Court has stayed seeking information from publisher, then how can you serve notices and how can you seek information? So the minutiae of drawing the lines between where internet freedom starts and where government intervention comes in seems a little unclear after this. Now, what needs to be seen, Griha, is that after this RTI, what will these activists do? Because it is now in the open that the government has gone ahead despite the court's decision and sought information from 2,100 publishers.
Absolutely, Ketan. Thank you so much for joining us with all those details. I'm also now joined on the broadcast by N.S. Napinai, who is a Supreme Court lawyer, and also joining me on Mirror now is Tanmay Singh, who is in fact from the Internet Freedom Foundation, and this is the same foundation that in fact had sought that RTI before the court. Ms. Napinai, I'll start with you first. Now, obviously, big questions there raised on the freedom as far as the internet freedom of people are concerned. Now, 2,100 organizations have already sought, have already really, been sent out this letter by the centre, and information has been sought, despite that stay by the Bombay High Court on these new IT provisions.
The difficulty here is this, that it is correct that only some of the provisions have been stayed by multiple courts. But on the other hand, when you look at Part 3 itself, the entire Part 3 is being brought in through executive action. So this is like delegated legislation, where under Section 79, there is a provision for intermediary guidelines to be issued. And under intermediary guidelines, the digital code has also been issued. I've been very vocal in saying that Part 3 cannot be sustained because it goes way beyond the Parent Act. Having said that, the challenge and the consequent order has been for certain sections, which is specifically under 9, 2 and 3. But the seeking of information is under Rule 18. The brazenness, according to me, of what the government is doing is, once these rules are being challenged, the wires are being challenged before court, before you start initiating action under it, you will evaluate the correctness of it. You will evaluate the legality of it to take a stand that only some provisions have been stayed and the rest are still under evaluation, and to say that we are therefore entitled to seek information. And if the persons from whom information has been sought want to contest it, let them go to court, is a little disproportionate and incorrect. More than a little, I would say. And I would say say that that's a little brazen by the government and not really acceptable. Ideally, once an executive action has been brought into question before a court of law, you would always wait to see what the court wants to say and why it's saying what it's saying. So if it has stayed 9, 2, and 3, what are the larger implications of the stay of a specific provision is something that the government ought to have evaluated before taking action like this.
Right, obviously. Tanmay, I'll come to you now. Now, the government, in fact, a representative of the government has also gone on record and said that what really has been stayed are only some provisions and not all provisions are under litigation. What has your RTI that you filed, what is the information that you got through it?
Right. First of all, I want to start by saying that it is incorrect to say that all of the rules are not under litigation. The entirety of the rules have been challenged in at least 15 to 17 petitions that are pending before at least 6 to 7 high courts of the country. And also to say that only a small part of the rules have been stayed is not the correct position. Rules 9.1 and sub-rule 9.3, which have been stayed, deal with the main thrust of chapter 3, of part 3 of the IT rules, which lay down the code of ethics and the self-regulatory mechanism, the 3-tier self-regulatory mechanism. Now, by the staying of Rule 9, effectively what will happen if you read the rules is that Rule 10 will be stayed, Rule 11 will be stayed, Rule 12 will be stayed, Rule 13 and 14 will be stayed, all the way, including the appendix and the schedules will be stayed. So it's not correct to say that only a small part of the rules has been stayed. I just wanted to say that, and I wanted to thank Ms. Napinai for very succinctly articulating what I wanted to say. Coming to the RTI itself, we came to know that the Ministry of Information and Broadcasting had sent these notices to digital news publishers, and we filed an RTI to understand the extent to which these notices were issued, to how many publishers have responded to it, and most importantly, how these notices have been issued after the order of the Bombay High Court, which was on the 14th of August, 2021. What we found was that the Ministry of Information and Broadcasting did indeed admit that they have issued these notices. The first was issued on the 26th of May in 2021. Now, this is before the Bombay High Court order, so that's fine. However, subsequent to the Bombay High Court order, nearly 3 weeks afterwards, on the 9th of September, they have admitted to sending a follow-up notice to all of these publishers. They have not revealed how many publishers, but they did admit that more than 2,100 publishers have in fact responded. We asked them 2 questions, which would serve as sort of follow-up questions. One being under what legal authority the follow-up notice was sent, given there is a Bombay High Court order operating. No response was received to that. And 2, how many publishers submitted that information after the Bombay High Court order of 14th August? Once again, we were told that no information exists. So that silence is a little bit deafening, I would like to say.
Also, Ms. Napinai, I want to bring you here. What we do know that, there are more than 10 petitions that are already, pending before the Supreme Court and the High Courts of not just Delhi, but also Madras, Kerala and Bombay. And this actually questioned the applicability of the IT rules as well.
Indeed. And that was what I pointed out earlier also. Once the delegated legislation has been taken to court, once courts are in seasons of the issue and they are deciding the same, to start actions thereafter is definitely not permissible, and at the worst and at the very least, it is definitely disproportionate. So what exactly the government would stand to gain from it is as follows, and that's the cause for concern here. You have a set of rules, that's the part 3 of intermediary guidelines, which have been contested. Now, you take an interpretation that some of the provisions, see, Tanmay is not completely wrong, he's right, and the very stay of 9.1 and the sub-rules of Rule 9 will impact various others. But the issue here is the better alternative would have been to stay Part 3 itself in its entirety, considering it's completely violative of the Parent Act. In any event, this is where we are today. But today, when the ministry asks for information, despite orders of the court and the pendency of cases before courts, then effectively what they are doing is they are collecting information and saying that we will face the consequences whenever the matter is decided in court. Until such time, let's make hay while the sun shines. And that is where I'm saying repeatedly that it is not permissible, it's misconceived, and it is disproportionate. Because often we have noticed that this kind of a brazen attitude of the government has actually benefited them, because they've collected information, then orders are passed which will go against this kind of collection. But in earlier instances, I have noted that the courts have not dealt with the issue of what happens to the data already collected. And now here is a situation where this has been highlighted because of this RTI, and it is important for the litigants in the various proceedings to not only protect against this kind of action, it is better that they get clarification from court on what is permissible and what is not, and most importantly also move for clarification on what should be done with data, if any, already collected.
That's already collected. Absolutely. A very important point, Tanmay, that Ms. Napinai has made over there, because the important thing to note here is over 200 media publishers really furnished the information to the INB ministry, and in fact there were 2 notices that were sent out to them. So it is clearly an unsuspecting media publisher goes ahead, furnishes the details because thinking the government is really asking for it. However, this has not been allowed by the courts.
That's absolutely correct. And some of the remarks, if you see the orders of the Bombay High Court and the Madras High Court, are very strong remarks. So, for example, the Madras High Court has noted that there is merit in the contentions of the petitioners, and there is a risk that this oversight mechanism to control the media by the government may rob the media of its independence, and the 4th pillar of the democracy may not at all be there. Now, in the face of these strong remarks from constitutional courts of India, to go ahead and act on what the ministry might say are small provisions which have not been stayed is not permissible at all. And I fully agree with what Ms. Napinai is saying.
Absolutely. In fact, you actually cued me to my next question there, Tanmay, and I would just open the floor to both you, Tanmay, and also Ms. Napinai. This is a very, very important debate that also was, that also ensued after this particular provision was put forth in the first place on the independence of the new media houses and also the OTT platforms, because there were a lot of content that was also being banned. There were a lot of YouTube channels which were to do with media were also on the radar. And, the entire question of dissent and whether a government machinery should be questioned also came to the forefront.
Yes, absolutely. And this is a debate that has been going on since the IT rules have come into place. And it's a big question as to how digital news media and OTT platforms can actually be regulated under these IT rules and under the IT Act, as Ms. Napinai has pointed out right in the beginning of what she was saying. These rules are completely ultra vires. The IT Act only empowers the Ministry of Electronics and Information Technology to regulate certain information technology related matters, not the Ministry of Information and Broadcasting at all. What is required here is an entirely different set of laws, a different act from the correct ministry, from the parliament, in fact, and not delegated legislation in this manner.
My take on this is very simple.